Good morning. May it please the court. The issue before Your Honour is whether Dr. Mira Strang should be permitted to give evidence in accordance with her report. The defence has served the report properly, and it directly addressed the accused's psychological state in lead up to the alleged offence. 2. Relevance. The starting point is relevance under Section 55 of the Evidence Act 2011, ACT. The accuser's mental state is plainly an issue, going directly to intent and capacity under Section 12 of the Crimes Act 1900 ACT. 3. The psychologist's evidence is capable of rationally affecting the jury's assessment of those matters. The threshold for relevance is low, and it is clearly met here. 4. Expert opinion. The opinion rule, Section 76, excludes opinions, but Section 79 provides the well-established exception for expert opinion. 5. The psychologist is a duly qualified clinical expert. Her report is wholly or substantially based on her specialised knowledge. That satisfies the statutory test. 6. The High Court in HG versus the Queen makes clear that experts may give opinions that assist the jury on matters outside ordinary experience. This report does just that. 7. Basis material and hearsay. The defence may object that the report contains hearsay, particularly the accuser's own statements, but this is standard in clinical assessment. Experts are entitled to rely on histories and self-reports to inform their opinion. 8. Section 60 of the Evidence Act allows such material, once admitted for a non-hearsay purpose, to be used as evidence of its truth. The jury can be directed on the weight to give it. 9. The critical point is that reliance on reported material does not render the opinion inadmissible. It simply goes weight. 10. Discretionary exclusion. Under Section 135, evidence may be excluded if probative value is substantially outweighed by prejudice. That is not the case here. 11. The probative value is high. The evidence addresses the very issue raised by the defence, the accuser's state of mind. 12. Any risk of prejudice is low and can be managed by judicial directions, rendering the jury that the psychologist does not decide intent. That is their role. 13. Application to this case. This report deals with three matters. 1. Background history. 2. The accuser's own accounts. And 3. Expert opinions on the likely impact of his psychological condition. 14. Each of these is admissible. Background provides context. The accounts are admissible on basis material, and the opinions fall squarely within Section 79. 15. If Your Honour has concern with isolated phrases such as references to propensity to act violently, those passages can be excised. Wholesale exclusion would deprive the jury of important relevant context. In summary, 1. The evidence is relevant under Section 55. 2. It is admissible expert opinion under Section 79. 3. It is not excluded by the hearsay rule. And 4. Its probative value outweighs any risk under Section 135. And finally, the Crown therefore submits that Dr. Mira Strang should be permitted to give evidence substantially in accordance with her report, subject only to excision of any passages Your Honour deems inappropriate. Thank you.